Namaste viewers and a very warm welcome to this episode of the Indian Lawyer Legal Tips. I am Sushila Varma, Advocate and Chief Consultant at the firm, bringing to you this special episode on Women's Day on the rights of Indian women. The role of Indian women in nation building is undisputed and has undergone significant changes in the last few decades. Today's modern Indian woman can participate and excel in various fields, be it politics, education, law, culture, or what you may have. Today's Indian woman is so bold that she can compete on the global platform fearlessly and with success. Traditionally, India had a very patriarchal society where there was male domination and women always had to play very subservient roles and had restricted freedom. It is because of the workers like social workers like Raja Ram Mohan Roy, Ishwar Chandra Vidyasagar and Savitribai Phule that there has been several changes in the last few decades on women's rights, helping the system to bring in gender equality. Now let us examine the first law that favors the Indian woman. This is the Indian Constitution 1950, which enshrines principles of equality, non-discrimination and social justice. The government recognizes that mere existence of principles is insufficient in addressing the inequality prevalent in society. Eventually, women-specific laws have been created to ensure that not only are they treated equally, but also provided with special protection and privileges in some cases to overcome systematic disadvantages. Enabling legislation, affirmative work, and landmark judicial decisions is what has shaped the laws for Indian women today. Over time, the Indian legal system has evolved in such a manner to address distinct challenges faced by Indian women in society. Now, the rights guaranteed under the Constitution of India are essentially Article 14, that is equality before the law. The law recognizes men and women on the same platform. In a very famous case, Air India versus Nargesh Mirza, 1981, a landmark judgment before the Supreme Court of India, Nargesh Mirza, a former flight attendant, challenged the airline's policy which dismissed female employees when they reached the age of 35 or got married. She argued that such policies were discriminatory and violated her rights under the Indian Constitution, particularly Article 14 and her right to life and liberty granted under Article 21. The Supreme Court ruled in favor of Nargesh Mirza, striking down the airline's discriminatory policy. The court held that these rules were unconstitutional because they imposed unfair restrictions on women based on their gender and were not based on any valid or reasonable grounds. This judgment was significant in advocating gender equality in workplace. Article 15 prohibits discrimination between men and women on grounds of religion, race, caste, sex, or place of birth. The case of Vasantha R versus Union of India 1993, again the Supreme Court of India, dealt with the issue of gender discrimination in employment practices of the Indian government, particularly concerning the retirement age for female employees. Vasantha R, a government employee, challenged the policy that mandated a lower retirement age for women compared to men. Women were required to retire at the age of 58, whereas men could continue working till they were 60. Vasantha R argued that this policy was discriminatory and violated the principles of equality enshrined in the Indian Constitution. The Supreme Court in its judgment ruled in favor of Vasantha R, holding that such differential retirement age for men and women was unconstitutional. This was another significant step towards addressing gender-based discrimination in government employment and reaffirmed the importance of equality in workplace. Now Article 16, which says equality of opportunity in the matter of public employment. The Constitution says that there will be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. By state, we mean the government, whether it's the state government or the central government. Now coming to Article 22. Article 22 asserts that no person, irrespective of religion, race, caste, sex, descent, place of birth, shall be deprived of their right to life except according to the procedure laid down by law. This article ensures the right to life encompasses the right to live with dignity and the right to livelihood and a healthy environment. Now coming to Article 13, which says that citizens, men and women, equally have the right to an adequate means of livelihood. Now let us examine another article, which is Article 14, that provides for just and humane conditions of work and maternity relief. The state has to make provisions for securing just and humane conditions of work and for maternity relief. Now let us touch upon a different aspect of women's laws, that is laws at the workplace. The first, and I would say a very, very important change that has come about in the corporate world is the Companies Act 2013. The Companies Appointment and Qualification of Director Rules 2014 is an excellent piece of legislation by which women get a representation on the board of directors. This particular rule states that in the case of every listed company, public company having a paid up share capital of rupees 100 crore or a turnover of rupees 300 crore or more must have a female director within 6 months of the date of fulfillment of the condition. The penalty in the event that these companies do not have a female director on its board can be from rupees 50,000 to up to rupees 5 lakhs. Now another very important legislation on the workplace, which is known as the POSH Act, that is Protection of Women Against Sexual Harassment at Workplace 2013. This act was passed by the government to prevent and protect women against sexual harassment and abuse in workplace. This legislation mainly strives to establish a favorable and safe working environment for women while they are working at a workplace. We have done a special episode on the POSH laws. In case you want to see it, the link is given below. The POSH Act drew its foundations from the Supreme Court's landmark judgment Vishaka v. State of Rajasthan, where guidelines were laid down for addressing sexual harassment at workplace. Section 4 of the POSH Act states that every company must constitute an internal complaints committee. This internal complaints committee will ensure that the employee who has any complaint can approach them and put their complaint in writing and request for some relief. Now Section 9, which talks about complaint of sexual harassment. Any aggrieved woman may make a complaint in writing of sexual harassment at workplace to the internal committee, and this committee must take the appropriate action within 3 months of this complaint being made. Now, what are the duties of the employer under Section 19 of the POSH Act? The employer has the duty of ensuring that the workplace is safe and that the women employees who are working there are safeguarded from any harm that can come to them at the workplace. Now let us address another aspect of women's laws, that is Occupational Safety Health and Working Code 2020, also known as the OSH Code 2020. The OSH Code emphasizes the health, safety and welfare of both male and female workers working in various sectors: industry, trade, business, manufacturing, motor transport, undertaking, construction work, etc. Now let us examine the laws for protection for women who are at home. The first, I would say, is the Protection of Women from Domestic Violence Act 2005. This act aims to provide protection for the wife from the wife or a live-in partner who faces violation from a husband or male live-in partner or his relatives. However, the act has come under some criticism because of the gross misuse by several women who have filed false cases against men, and this has therefore led to a requirement for gender neutral provisions to serve the justice for men. However, as we talk, the Protection of Women from Domestic Violence Act is an act that protects women who are at home. Now, under this particular act, there is a section 5 where there are duties of the police officer, duties of the police officer and the magistrates to inform the aggrieved person of a right to make an application and to obtain relief by way of a custody order, protection order, residence order, compensation, or any order for monetary relief. Section 6 provides for shelter homes. If an aggrieved person does not have a home, the protection officer can provide access to a shelter home for her. Section 7 provides medical facilities to an aggrieved person in the event that she is without any income and she requires medical facility. Section 8 of this Act also provides for the appointment of protection officers in each district who have the duty to take down the statement of an aggrieved person and to help her to bridge the gap between the domestic violence and the court. Now, what are the duties and functions of the protection officer? Essentially, it is to make a domestic incident report, also known as DIR, which is a report made in the prescribed form in order to ensure that the aggrieved person has an audience before the concerned magistrate. Section 12 of the same Act provides that the aggrieved person or any other person or the protection officer or the service provider on her behalf can file an application to the magistrate claiming relief under the Protection of Women from Domestic Violence Act. This Act at Section 17 also gives the right to reside in a shared household to every woman who is in a domestic relationship and where she is residing in a shared household. Now let us look at the marriage laws, in particular the Hindu Marriage Act 1955. There are of course other laws for women, that is the Special Marriage Act, the Muslim laws, etc. But we are in this particular episode only dealing with the Hindu Marriage Act. The laws are quite common in all three types of laws because they have more or less a similar grounds for divorce. Now, the Hindu Marriage Act 1955 provides under section 13 grounds for divorce. These are mentioned in the screen. Apart from this, there is a section 24 which allows a Hindu woman who is undergoing a divorce proceeding to apply for maintenance and expenses that will be incurred in the litigation in court. Section 25 provides permanent alimony and maintenance, that is, a woman who is undergoing a divorce proceeding can apply to the court for getting alimony and maintenance. Moving on to the next type of law, that is the succession laws. Succession laws are of course religion specific. We are dealing with the Hindu Succession Act, where Article 14 provides that the property of a female Hindu will be her absolute property and no one can insist that she should give her property to a third party. The Hindu Succession Act, Amendment Act 2005 is also a very big change in which they have removed gender discrimination by providing that the daughter of a co-partner shall become a co-partner in her own right in the same manner as a son. Now, the testamentary laws. Section 30 of the Hindu Succession Act says any Hindu can dispose of their property by will or testamentary disposition, any property which is capable of being disposed of either by him or her. This means that a woman can write her will as per her own wishes. Now coming to the criminal aspects. The Bharatiya Nagrik Suraksha Sanhita 2020-23 is the act that replaces the Criminal Procedure Code that was earlier in force. Now section 144 of this particular act provides maintenance to wives, children and parents in case they do not have sufficient means of looking after themselves or are neglected or are refused to be maintained by their spouse, children, or the parents. This particular section also allows an illegitimate child, whether married or not, to also ask for maintenance, or an illegitimate child who is a daughter who has attained majority but is not married, she can also ask for maintenance from her parents. This section replaces the earlier section 125 CRPC. We also have the Dowry Prohibition Act 1961 that safeguards women from dowry demands. The Dowry Prohibition Act is a law enacted by the Indian government with the objective of eliminating the practice of dowry in marriages, which has been a long-standing social issue in the country. The Act criminalizes the giving and taking of dowry, and it aims to protect women from the abuse and exploitation that is often accompanied because of this practice. Section 3 lays down a penalty for people who are giving or taking dowry, and the punishment can be for a term of up to 5 years with a fine, or with a fine of not less than 15,000 rupees or the amount of the value of such dowry. Section 4 is again a section that has a penalty for demanding dowry. In this case, there can be imprisonment along with fine. The imprisonment can be up to 2 years. There is a section 6 where it states that dowry is to be for the benefit of the wife and her heirs. That is, if anyone has given dowry to a woman, that dowry is supposed to be used by her only for her own use and not for any third party. Now let us examine the criminal laws that protect women. Today the criminal laws are codified under the Bharatiya Nyaya Sanhita 2023, which replaces the Indian Penal Code. The first section is section 63, which deals with provisions of rape and the punishment for rape, which will depend on the type of rape that the person has committed. It could be 10 years to life imprisonment, depending on the age of the person who has been raped. There is also a provision, section 67, for marital rape, and for this also there is an imprisonment from 2 years to 7 years. Then there is a section 77 that talks about stalking, and this is also punishable with 3 years of imprisonment and fine. And there is one section 78 which talks about insulting a woman's modesty by using words, gestures, or objects. For this also there is a punishment of 3 years and fine. With this, I end this episode on laws in India that protect women. I wish all women a very happy Women's Day, and I wish you all the best to grow from strength to strength and make the India proud of us on the global platform. If you have found this episode useful, please like, share and subscribe, and please help us to reach a larger audience, because we are doing a social service of trying to create awareness of the law. Thank you. Till we see each other in the next episode.